If I could get you to grab your seat as soon as you grab a sandwich over there, or get up later to grab a sandwich. Good afternoon. I'm Randy Hanna, and I'm the dean here at Florida State University Panama City. Yeah, you can clap. And you can also do Go Noles. Go Noles. I see a lot of friends out here. We have a lot of students. We have professors. We have colleagues from Tallahassee here. We have judges, which is probably why there are a bunch of lawyers here, because there are judges here. We have folks from the state attorney's office, I see, possibly some from the public defender's office. And we have some folks from who came here because of the Osher Lifelong Learning Institute. And we invited them to this debate discussion on the First Amendment. And we're thrilled to have it today and very honored to have our pre-law club participate and our two participants in this discussion. Thank you all for coming, and go Noles.
All right, welcome again. Thank you for coming. I'm John Mooneyham. I'm a judge of compensation claims, which is the workers' compensation judge, and I'm pleased to be the legal advisor of the FSU Panama City Pre-Law Club. This is them sitting right here. Raise your hands. And I'm going to be the moderator for today's festivities, and I'm probably one of the last people you won't moderate in the debate on constitutional law. Although I graduated with honors from FSU College of Law, the only D I ever made in my life was in constitutional law one semester. So I need to remind my old classmate, Eddie Bell. Eddie, raise your hand. When Coach Free popped me with that paddle, it was for getting a C in typing. It wasn't a D. Coach Free was a basketball coach, and you got 2 swats for an F and 1 for a D. I'll tell you what, my constitutional rights were definitely violated that day. It was cruel and unusual punishment without equal protection or due process of law. What's the statute of limitations on that, Professor Harle? I also like to thank Dr. Hoover. Where's Dr. Hoover at? Pre-Law Club faculty advisor. Other people who make this event possible, Jennifer Araldo from the Pre-Law Club, the treasurer. Where's Jennifer? Jennifer set up the room, did the flyer, did basically everything here. So thank you, Jennifer. I'd like to thank Dean Hanna and Dr. Clark for their support of the Pre-Law Club. They've been great, rolled out the red carpet for us, as I have said before, and I really appreciate everything they've done in supporting us. So thank you. Becky Keller, Director of Advancement. I don't think Becky's here today. I didn't think she was coming because I asked her 6 weeks ago, are you coming to the debate? She said, are you moderating again? Stephanie Smith, Facility Use Coordinator for setting up this beautiful room. Tony Simmons, Audio-Visual Program. Appreciate this. And Courtside Cafe for the food. And especially our 2 debaters, Mike Stone and Professor Harle. And then we got some special guests I want to recognize. My assistants, Jennifer and Stacy back there. They're excellent. And it's hard to be a high-level attorney without high-level people working with you, so I certainly have that. We got Mark Sims, the public defender for the 14th Judicial Circuit. Mark's one of the biggest supporters of the Pre-Law Club and always has been, so thank you, Mark. And then my boss, Judge David Langham, right there. He doesn't like the limelight. I'm comfortable exercising my First Amendment rights in front of Judge Langham because he has assured me they can't afford to lose someone with my knowledge of constitutional law. And then my colleagues and friends, Judge Jackie Newman and Judge Jonathan Walker there as well. So thank you all for coming. They came from Pensacola and Tallahassee. And let me just tell you about the format, and then we'll get going. We're going to introduce our speakers, have a reading of the First Amendment, a presentation of the summary of the Childs versus Saladar decision that we're going to discuss today. The facts of the case as well will be presented, an explanation of the constitutional standards of review, and then we'll have a debate where each of our debaters have 5 minutes, then they'll have a 2-minute response. Then they submitted some questions that we're going to ask them and get their response to those questions. Then the audience will have an opportunity to ask questions, and after that's done, Professor Harle is going to speak about the First Amendment Clinic and then answer some questions about the First Amendment Clinic and any other questions that you have. So we've got a number of students that volunteered to help with the program. So I need, Lindsay, if you could come up here and introduce Professor Harle, please.
Professor Harle is a clinical professor and director of the First Amendment Clinic at the FSU College of Law, where she leads student advocacy and litigation on free speech, religious liberty, and press freedom issues. She earned her JD cum laude from Duke University Law School and her BA and BS summa cum laude from FSU. She also earned a master's degree from Stanford University, where she taught undergraduate courses on public policy, law, and American politics. She continues to serve as a dissertation faculty advisor for Concordia University, St. Paul, mentoring doctoral students in research and writing. Before entering academia, Professor Harle was a partner at Schutz & Bowen in Tallahassee, where she was a member of the firm's appellate practice group and constitutional law practice area. Before that, she practiced public interest law for 6 years as a senior counsel with nationally renowned legal nonprofit focused on free speech and religious freedom. Before that, she served as a Deputy Solicitor General in the Office of the Florida Attorney General and was a judicial clerk for Justice Ricky Polston on the Florida Supreme Court. Professor Harle has briefed and argued high-profile cases involving significant constitutional and statutory interpretation issues in both state and federal courts, including the U.S. Supreme Court. She has also testified before the U.S. Senate on constitutional matters. A frequent speaker and media commentator on constitutional law, Professor Harle has been quoted in the Wall Street Journal, the Washington Post, the New York Times, and has appeared on national outlets, including C-SPAN and Fox News.
All right, thank you, Lindsay. Alex is going to come up and introduce Mr. Stone.
Mr. Stone has practiced law in state and federal courts for over 40 years. He has the highest peer review rating from Martindale-Hubbell. Currently, he handles personal injury and criminal defense cases. Mr. Stone graduated from Bay High School, where he was the valedictorian and student body president. He was also named a presidential scholar. He graduated from Harvard College cum laude. He received a JD degree from New York University Law School, where he was selected as a member of the Order of the Coif and served as editor-in-chief of the Review of Law and Social Change. During law school and for 2 years after graduation, he worked for a New York City law firm focusing on white-collar crime and civil litigation cases. Returning to Panama City, Mr. Stone joined the Office of the Public Defender, during which time, for 10 years, he served as chief of the Capital Division for the 14th Judicial Circuit, defending all death penalty cases arising in the 5 counties compromising the circuit. He has given lectures at FSU Panama City, taught torts and personal injury at Bay High School, and been the featured speaker at ACLU-sponsored events. For many years, he served as president of the Bay County ACLU chapter. He also joined 2 retired judges in teaching a continuing education course on the Constitution and the Bill of Rights at Gulf Coast State College. Thank you.
Thank you, Alex. And Tyler's going to come and read the First Amendment to us.
Thank you. The First Amendment states, Congress shall make no law respecting an establishment of religion, or prohibiting the exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Thank you.
And Professor, through a process known as incorporation, the First Amendment applies to individual states, correct? Most? Okay, well, you'll give me a correct answer for that one. All right, so now with a presentation of the facts of the case, Jennifer Harle.
Good afternoon, everyone. Kaylee Shiles is a licensed professional counselor practicing in Colorado. She has a master's degree in clinical mental health and provides talk therapy, specializing in clients dealing with addiction, trauma, sexuality, gender dysphoria, and other mental health concerns. Shiles is a Christian, and her clients often seek religiously informed care that aligns with traditional biblical understandings of sexuality and gender. In 2019, Colorado enacted a law banning the provision by healthcare professionals to minors of conversion therapy, which is treatment that attempts to change a person's sexual orientation or gender identity. However, the law allows treatments that provide acceptance, support, or understanding of a person's sexual orientation or gender identity. Before the law's passage, Shiles counseled clients, including minors, in accordance with their self-identified goals, which sometimes included diminishing same-sex attractions or aligning gender identity with biological sex. Since the law's passage, Shiles has refrained from engaging in discussions with minors that she believes could be interpreted as conversion therapy, and alleges that this has hampered her ability to provide full counseling services in line with her and her clients' religious convictions. In September 2022, Shiles brought a pre-enforcement lawsuit alleging that the ban on conversion therapy for minors violates her rights under the free speech and free exercise clauses of the First Amendment. Seeking a preliminary injunction, she asked the district court to block the enforcement of the law against her. The court denied the motion, but found she had standing to proceed. On appeal, the U.S. Court of Appeals for the 10th Circuit affirmed in full, holding that Colorado law regulates professional conduct that incidentally involves speech, applying a rational basis review to determine that the law was not unconstitutional. Thank you.
All right, thank you, Jennifer. The decision we're reading today has a majority opinion, a concurring opinion, and a dissenting opinion. We're going to have a student read a summary of each of those, so I need Kathy, Nick, and Florian just come up here, and then Kathy will start with the majority opinion.
Summary of Childs versus Salazar Supreme Court decision. Majority opinion written by Justice Gorsuch. On March 31, 2026, the United States Supreme Court, in an 8-1 decision, reversed the 10th Circuit decision to uphold a Colorado law prohibiting licensed medical professionals from providing conversion therapy to minors. The court remanded the case to be rescinded under a strict scrutiny standard of review, holding that the law regulates speech based on a viewpoint. The court rejected the argument that talk therapy is professional conduct that can be regulated by the state, noting that speech does not become conduct just because it is also be described as a treatment or a therapeutic modality. The court further noted that the Colorado law does not regulate speech incident to conduct, but noted that it regulates speech as speech. The court recognized that the First Amendment's protections extend to a licensed professional as much as they do to everyone else. The court provided that the Colorado law did not regulate the content of Ms. Child's speech, but it also prescribed what views she may and may not express by seeking to silence a viewpoint she wishes to express.
Concerning an opinion of Justice Kagan that was joined by Justice Solomore, Justice Kagan, that the Colorado law, as applied to talk therapy, conflicts with the core First Amendment principles because it regulates speech based on viewpoint. Justice Kagan provides that she writes only the note that if Colorado has instead enacted a content-based but viewpoint-neutral law, it would raise a different and more difficult question. Justice Kagan provided that in judicial care typically involves speech, so the regulation of Medicare, which is course of persuasive, may involve speech restrictions, and those restrictions will generally refer to the speech content, but she noted that the speech restrictions will likely trigger a strict scrutiny standards of the review if the restrictions are viewpoint-based. Justice Kerrigan asserted that Justice Jackson, in her dissent, rejected that the well-said distinction between viewpoint based on other content is based on speech restrictions.
This is the dissenting opinion of Justice Jackson. Justice Jackson provided that the states have the police power to regulate medical treatment provided by healthcare professionals, even if the regulation applies to and restricts speech based on its content. She noted that the Colorado law treats conversion therapy as a prohibited medical treatment, but that the purpose of the law was not to suppress speech, but to prohibit a harmful medical treatment. Justice Jackson noted that the Colorado law does not prevent Ms. Childs from talking about the efficacy of conversion therapy, but that it only proscribes the provision of such therapy to minors. She noted that since Ms. Childs' speech is only incidentally restricted, heightened scrutiny is not warranted. Justice Jackson provided that the regulation of the practice of medicine is always viewpoint-based because a standards-based healthcare scheme cannot function unless its regulators are permitted to choose sides. Thank you.
Thank you, Kathy, Nick, and Florian. And at this time, I think Professor Harle wanted to explain the constitutional standards of review that judges use in deciding constitutional law cases.
Judge, since you have such a tight agenda here, would you mind if I fold in the standards of review while I'm doing my opener? Is that good? Absolutely. Okay, that'll save us 2 minutes.
Absolutely.
Okay. Good afternoon. Thank you all for having me. We've been looking forward to this for a long time. Lots of planning going into this. So this case asks whether the government can restrict what a licensed counselor says to a willing client solely based on the viewpoint the counselor expresses. The First Amendment answers that question clearly. The state government cannot do that. Colorado's law does not regulate conduct in any ordinary sense. It doesn't target malpractice or coercion or fraud, areas where the state unquestionably has authority. Instead, it regulates pure speech, conversations between a counselor and a client. And it does so in a way that is both content-based and viewpoint-based. Under the statute, a counselor may affirm a client's gender identity or encourage a particular direction of self-understanding. But if a client comes in seeking to help live in accordance with different goals, perhaps grounded in personal faith or conviction or just a desire to change, the counselor is forbidden from engaging in that conversation. The exact same therapeutic techniques, the same tone, the same setting, are all permitted or prohibited depending entirely on the message of the words spoken.
This is the definition of viewpoint discrimination. The Supreme Court has repeatedly held that viewpoint discrimination is an egregious form of speech regulation that is presumptively unconstitutional. And this is getting into the constitutional standard. Case after case says this. When the government engages in that kind of viewpoint discrimination, the highest level of constitutional legal standard, strict scrutiny, applies. The Supreme Court correctly ruled here that Colorado can't satisfy that standard. Well, they didn't necessarily rule it. They remanded it back to the lower court with huge writing on the wall. There are major red flags in this law. But they said you have to apply the strictest scrutiny here for viewpoint discrimination. So the ruling by the Supreme Court is correct for at least two reasons. First, the state doesn't have a compelling interest in manipulating the marketplace of ideas within a counseling room. In order to satisfy strict scrutiny, the state would have to prove a compelling interest and that it's narrowly tailored so that the law is the least restrictive means of advancing that compelling interest. There's no compelling interest in manipulating the marketplace of ideas in a counseling room. The government can't declare that certain viewpoints are too dangerous to be spoken, especially when both the client and the counselor are choosing to have these conversations. The First Amendment protects not only the right to speak, but also the right to hear and receive information and ideas. Second, even if the state's interests were framed as aiming to protect clients from harm, the law is not narrowly tailored. It doesn't meet that second prong of the strict scrutiny standard. It's over-inclusive and it's under-inclusive. It bans entire categories of speech regardless of the client's wishes or their individual circumstances or the manner in which the counseling is conducted. At the same time, the law allows other conversations that could be just as consequential or sensitive. That mismatch reveals what's really going on. It's not a neutral protection, it's a one-sided ideological regulation. The state attempted to characterize the regulation as a regulation of professional conduct. But the Supreme Court rejected that exact argument in a case that I had the incredible opportunity to write the Supreme Court briefs for, National Institute of Family and Life Advocates versus Becerra, better known as NIFLA. There, the Supreme Court made clear that there's no separate category of professional speech that receives diminished First Amendment protection. When professionals speak, they're still engaged in speech, and the First Amendment still applies. Of course, the court has recognized that some regulations of professional conduct may incidentally affect speech, but that was not this case. Here, speech was the entire object of the regulation. The law targets what was said, when and where it was said, and the viewpoint it conveys. The state also can't rely on cases involving informed consent in the medical context. Those cases permit the government to require the disclosure of truthful, non-misleading, relevant information as part of obtaining consent to a medical procedure. But informed consent laws don't authorize the state to ban disfavored viewpoints or to prohibit entire categories of discussion between professionals and clients. In fact, the Supreme Court's more recent decisions reinforce that principle that the government can't compel or restrict speech to enforce a certain orthodoxy. In the 303 Creative case that was decided in 2023, the Supreme Court held that the state may not force a speaker to express a message she disagrees with. And in numerous cases, the Supreme Court has emphasized that regulations that target the content of a message are subject to strict scrutiny regardless of the government's intentions, good or bad. Those principles apply with full force here in this case. Stepping back, we can see why these constitutional concerns have real human implications. This law interferes with the autonomy of both the speaker and the listener. Clients come to counseling with diverse goals. They may seek affirmation or transformation or clarity. The First Amendment protects their ability to pursue counseling consistent with their own values, and it protects the counselor's ability to respond honestly and professionally. By shutting down one side of that conversation, Colorado effectively imposed a state-approved orthodoxy within the counseling relationship. It tells counselors what they may say and tells clients what they may hear. That is exactly the kind of government control over ideas that the First Amendment prohibits. The implications extend far beyond this case. If the state can restrict speech in counseling based on viewpoint, it can do the same in other professions: law, education, medicine. Whenever speech touches on contested moral or social questions, that would mean the state can prohibit an entire viewpoint. The logic of the state's position in Colorado has no logical stopping point. So to be clear, the plaintiff here did not challenge the state's authority to regulate harmful conduct. Laws prohibiting coercion or deception or medical malpractice remain fully intact. What the state can't do is silence disfavored ideas in voluntary consensual conversations simply because it disagrees with the message. The First Amendment doesn't permit the government to act as a gatekeeper of acceptable thought. It does not allow the state to prefer one viewpoint over another. And it does not allow officials to decide which personal goals are permissible and which are not. In a free society, decisions about which personal conversations and goals are appropriate belong to the individual, not to the government. For those reasons, the court was right to conclude that Colorado's law likely violates the First Amendment and to reaffirm the longstanding principle that freedom of speech includes the freedom to engage in open, honest dialogue, even and especially on matters of profound personal importance. Thank you.
Mr. Stone, you can reply why is the decision majority reached incorrect, and you can sit or you can stand, whichever you'd rather do.
What would you like? Should I stand or sit? Sit. Okay, good. That's what I was going to do anyway. You know, you've been brought here today under false pretenses. This is not a First Amendment case. It's a case of the legitimate and valid police power of the state of ancient origin to protect the health and welfare of its citizens. What's remarkable about the Childs versus Salazar opinion by the Supreme Court is that they don't even mention the reason why Colorado has banned the giving of conversion therapy to minors. And yet the whole case resides there, as the dissenter, Jackson, pointed out. And she starts with a sentence that I think is very important from a 1926 case of the Supreme Court, and it goes something like this: there is no right to practice medicine which is not subordinate to the police power of the state. Now, don't freak out with the phrase police power. We're not talking about sending ICE into every clinic. We're talking about basically the power of the state to police certain conduct which may be harmful to the citizens. Colorado has, like 27 other jurisdictions in this country, determined that conversion therapy is an ineffective and harmful practice, especially where children are concerned. Therefore, it has banned the giving of that therapy by licensed mental health practitioners only. It has not banned the churches from putting together a conversion therapy picnic, if they wish, and giving the therapy to the children, the helpless children. They have not banned anyone from advocating for conversion therapy. They have not banned licensed practitioners from giving conversion therapy to adults. They have very narrowly limited the protections to minors. Now, I'm assuming that most of you or all of you know what conversion therapy is. You may not know that historically conversion therapy efforts have included aversive therapeutic modalities. Those ranged from inducing nausea, vomiting, or paralysis in patients, or subjecting them to severe electric shocks, to telling patients to snap an elastic band on their wrist in response to non-conforming thoughts. How about that for a therapy? Every major organization concerned with health, especially children's health, has declared conversion therapy not only ineffective, but harmful. And we're talking about the modern version of conversion therapy, which is talk therapy, entirely talk therapy. No more rubber bands. It has been banned, this talk therapy, by the American Psychiatric Association since 1998. In 2009, it was rebuked by the American Psychological Association. It's also been rejected by the American Academy of Child and Adolescent Psychiatry, the American Academy of Pediatrics, the American Medical Association, the American College of Physicians, and the American Academy of Physician Assistants, and many more. Now, a 2025 study completed by the American Medical Association found that 42% of those subjected to conversion therapy attempted suicide. 42%, compared to 5% of those not subjected to those practices. A similar study by the Trevor Project came to the same conclusion. 42% of LGBTQ plus youth who underwent conversion therapy reported a suicide attempt in the past year. Now, for transgender individuals in particular, exposure to conversion therapy before age 10 is associated with a 4-fold increase in the risk of lifetime suicide attempts compared to peers who received other forms of therapy. And I could go on and on and on. The United Nations has banned it. The World Health Organization has banned it. It's been called cruel, inhuman, and degrading treatment in the European Union. It's been dubbed torture, and it's even been called child abuse to subject children to this stuff. Some jurisdictions have criminal bans on the practice of conversion therapy, including Canada, Ecuador, France, Germany, Malta, Mexico, and Spain. Now, digging into this a little deeper, the American Psychological Association, APA, for example, has found, quote, no empirical evidence that providing any type of therapy in childhood can alter adult same-sex sexual orientation. The reason for that, of course, is that these orientations are formed at birth. It's genetic. It's not something that you pick up from the local whatever treehouse or something. No research has been published in the peer-reviewed literature that demonstrates the efficacy of conversion therapy efforts with gender minority youth, nor any benefits of such interventions to children and their families. Not only is conversion therapy ineffective, former participants of conversion therapy report that it causes lasting psychological harm. Gay and transgender children who underwent non-aversive conversion therapy, talk therapy, say they were taught to feel shame and self-hatred. And survivors of conversion therapy continue to suffer from PTSD, anxiety, and suicidal ideation even into adulthood. As one survivor put it, conversion therapy came close to killing me. By the way, there's a Netflix movie called Boy Erased, which you can, I think, still access for free, starring Russell Crowe and Nicole Kidman. If you're interested in this topic, it's not a comprehensive view of conversion therapy, but it does give you an idea of what these kids have to put up with. Now, with all of this evidence of ineffectiveness and harm, the Colorado legislature was well within its traditional police power in banning the practice in the limited way it did. This is no different in principle from the state declaring that doctors may not prescribe dangerous drugs or perform foolish, unnecessary surgeries or advise obese people to increase their intake of fat or sodium or urge young people to take up smoking or drinking, or, as Justice Jackson suggests, encourage patients to commit suicide, or tell an anorexic patient to eat less. All of these things can be legitimately banned by licensing organizations and have been, and conversion therapy falls right into that lot. But the majority opinion, the 8 justices, are remarkable in failing to even mention the mountain of evidence that I've just now alluded to. And there's a lot more I could have given you, but I'm probably over time already. Evidence that shows that conversion therapy is both useless and dangerous. Now, the fact that conversion therapy is given entirely by talking now makes no difference. The speech is incidental to the conduct. Put another way, the conduct cannot be effectuated without using speech. And as the court said, or Justice White concurring in 1985, the power of government to regulate the professions, including medicine, is not lost whenever the practice of a profession entails speech. So I contend that the rational basis test is appropriate. That's the, I'm not sure we discussed that. The least strict scrutiny is given to conduct that, or laws that have the least bad effect on free speech. And I would maintain that the rational basis test is appropriate here, where the state has to show a legitimate interest, merely a legitimate interest in the health and welfare of children. Of course it has such an interest. Where conversion therapy has been proven to be harmful and ineffective, the law banning conversion therapy is rationally related to the goal being promoted or the harm being avoided. In other words, the state has not, my colleague referred to these sweeping bans on all kinds of talking and thinking, but the ban here is very narrow, very precise, and doesn't even prevent conversion therapy. If you really want to get it, you can go to your favorite church or to a non-licensed therapist and get it, even if you're a kid. And adults can get it from licensed therapists. So what the hell is the problem here? The court, I think, got a little bit hysterical on the speech question. It's just not a First Amendment case.
Thank you, Mr. Stone. We're actually going to keep time like I was supposed to do on that one. So our official timekeeper over there, Ryan, raise your hand, Ryan. So everybody's going to have 2 minutes to respond. And when you get to 30 seconds, just do that, yeah, and then close your hand when it's 0. So Professor Harle, would you like to respond to Mr. Stone?
Sure, yeah. I'm thankful you started with the definition of conversion therapy, because I actually think it's important that we're talking about the same thing. And recognizing that today conversion therapy involves talking and not those really horrific, outmoded versions that have been thankfully abandoned and condemned by different medical societies. So of all the evidence, though, and reports that you mentioned, all of those are about the outmoded versions. So it was recognized in the briefing and at oral argument that there is 0 evidence of harm coming from talk therapy. 0. There is not one study saying that talk therapy is harmful to minors who are struggling with gender dysphoria. And so that's why the speech conduct distinction is so important. If we say that speech is the act of speaking, therefore it's an act, therefore it's conduct that the government can regulate, then what is the limit? If we just simply say pure words are conduct, and the state can, if they have any rational reason, can come after the words. I am not comforted at all by the fact that other people besides licensed mental health counselors may still speak those words in Colorado, because I'm actually even more suspicious when the government starts deciding which speakers can talk and which can't. That troubles me just as much as when the government's saying which ideas can be spoken and which can't. So for me, I view this completely as a First Amendment issue, and glad that 8 of the justices agreed with that.
Mr. Stone, would you like to respond?
That was 2 minutes already? Wow. Okay. Yeah, I'd like to respond to that, but I don't know how. One thing I would say is that if it's true that there's not a single study showing that kids are harmed by conversion therapy, why in God's name did not, that's a pretty good reference, did the court not cite that fact in its opinion? The court devotes not a word to the evidence, pro and con, of the harmfulness of this therapy. Justice Jackson takes her whole opinion to talk about it. There's something wrong here. I think the court is ignoring the harm because it has a mission to basically, really it's a viewpoint mission. The court takes a dim view of modern medical understandings that this conversion therapy is a bad thing. And the court takes an expansive, favorable view of religious apologies for conduct like this. And that's I can show this with, if my time has probably run out, but I can show this with cases that, was that 30 seconds? Let me try to do that very quickly. I've made some notes of some leading cases in over the years, including some very recent ones, which I think tend to show. Professor Chemerinsky of Yale, I believe, made this point.
He's at Berkeley. He taught me Fed courts.
He's at Berkeley now?
Yep.
I think he was at Yale, but I don't
He was
know.
at Duke. He was my professor.
Oh, really? Well, then you shouldn't be saying
I stole
what you're
time
saying.
from him. I apologize.
No, he points out Planned Parenthood versus Casey. 1992 was a case which upheld a law requiring doctors to give info to a woman deciding whether to proceed with an abortion. And the information was kind of negative, you know, wouldn't you rather have a kid and stuff like that. Court saw no reason why the state may not require doctors to advise abortion prospects of the availability of materials related to the consequences of the pregnancy, even when those consequences have no direct relation to her health. So they upheld that law. But then in Becerra, your case, in 2018, they struck down a couple of laws. A California law that required reproductive health care facilities to post a notice that women who economically qualify can receive free or low-cost contraceptives and abortions paid by the state. Licensed facilities could no longer do that. And unlicensed facilities, the law said, had to post a notice saying that they are not licensed to provide medical care, which is true. The court struck that down as well. So how do you reconcile Becerra and Casey? I don't think you can.
Maybe because, well, Casey's been overturned. You probably know that. In another case I worked on called Dobbs in 2022.
Right.
So it's not.
There's a lot of
good law.
cases that I still hold to, even though they've been overturned. I had a judge once, Judge Bauer, who used to say, sometimes the first DCA reverses me, and sometimes I reverse them. Anyway, and let me skip a couple of cases, but Skermetti and Childs are another thing. Skermetti, 2025, upheld a Tennessee law prohibiting gender-affirming care for transgender youth and proclaimed the need to defer to the state legislature in making a decision with regard to medical treatment. What happened to that in Childs? They strike down the Colorado law in favor of the free speech rights, so-called, of the therapist, and they don't even mention deference to the Colorado legislature or any of that mountain of evidence that I gave you a taste of. They don't even mention it. How do you reconcile these two approaches? I think the only way to do so, the only consistency, the only predictor of what the court will do seems to be that if the law favors abortion or LGBTQ rights, SCOTUS disfavors it. In general, SCOTUS is making value judgments about whether it likes federal regulations or not.
All right, thank you. And what I would suggest, if it's all right with our debaters, is that we skip our questions that we wrote out and just, unless you all have got something you want to address, and just take audience questions, because you addressed most of the questions in your debate already. But you got something you want to address,
I
Professor?
mean, I don't need to get the last word, but you asked some questions that I was going to maybe respond to.
Well, go ahead.
Briefly? Okay.
This is
great.
a Sir rebuttal. Oh, do we have Sir rebuttals?
On behalf
We
of
do now.
Justice Sonia Sotomayor, I'm sure she's very offended by you right now, putting her in the category of going against abortion and LGBTQ. But I did want to talk about the Scrimeti, because again, I feel like this underscores the position I'm taking, which is the distinction between speech and conduct. So the law in Scrimeti specifically was regarding medical procedures, puberty blockers, cross-sex hormones, and surgeries on minors. So that's what the law targeted, was removing healthy body parts from children and adolescents, or giving them hormones for the purpose of helping them try to transition to another gender, right? So that was all actual medical procedures. It did not target speech, versus the Colorado law only targeted speech, and it from the perspective of minor clients who are asking that they want to become more comfortable in their own body. So for me, I think the Scrimeti was different again on that difference between speech and conduct.
That's true. It's not a free speech case. But, you know, you can throw the baby out with the bathwater here. You're so desperate to protect what you call free speech that you're willing to let children risk suicide.
I mean, I will say there was a Finnish study that just came out earlier this month this was on adults that have been followed for over 2,000 individuals, followed for I think 23 years now, who went through the gender transition process and have substantially higher bad mental health outcomes, as well as a 19 times higher suicide rate. And so I think there's not a consensus on what is the best treatment for people experiencing gender dysphoria. There really is no medical consensus. But again, the Colorado situation was a client coming to the counselor asking for help to become more comfortable in their own bodies based on their sex. And so for clients that want that, you know, to ban that type of speech is problematic on a number of levels.
Well, I don't see anything wrong with requiring clients who want that to be adults so that they are old enough to make that decision, whether they want this therapy or a drink or a cigarette. You know, they have to be an adult to do it. But Finland, you were talking about Finland?
Yeah, very progressive.
I thought that was the happiest country in the world.
Apparently not those who have gone through gender transition.
Or Denmark, okay, whatever. It's so cold up there.
All right, are you both okay just taking questions from the audience now?
Yes, sir.
Sure,
All right.
if they're good
And,
questions.
If we need a volunteer to take a microphone around, somebody from our pre-law club. Lindsay, I saw Lindsay's hand first. Could she borrow your microphone? You all share that one?
Sure.
I think this
Yeah.
it's not working over here. We'll get it. Does anybody have a question? Eliza?
Hi. So a recent law that was passed in Florida banned teachers in schools for talking about any sexual orientation or religious beliefs because they have an authority figure over the children. I guess what would be different from this with the licensed mental health individuals, because they have an authority and a way over the children as well. So I guess what's the difference between in schools and in the licensed mental health field?
Was this relating to public schools?
Yes,
Okay.
yes, ma'am.
Yeah. So there is actually a different speech analysis for government employees and government officials. So I was actually talking about this in the lunch beforehand, where if for public school teachers, right, or governments, their employees who are public employees, they actually do pay their employees to do things, right, to speak, right? They're paying the public school teachers to provide a certain education, provide a certain curriculum, and it does empower the government to have more control over their employees' speech in that particular setting versus just a private citizen. So that is a big distinction. It's not a perfectly clear area of law. For example, I was mentioning how we weighed in favor of a teacher who wanted to keep a small crucifix kind of behind her desk, and she was told she couldn't do that because it was like a promotion of religion in a different state. And I think that goes too far, right? I don't think that everyone has to shed all of their personal opinions or their religious beliefs at the door just because they want to be a public school teacher. But when you're talking about communicating in the classroom, the Supreme Court has found that there's greater authority by the state.
Thank you.
This case involves regulating mental health professionals, and speech is a part of counseling, and so doesn't stopping the government from regulating the speech of mental health professionals, doesn't that stop them from regulating any kind of the medicine, right? Doesn't that, right?
Well, I wouldn't say so, because here we have a law which specifically and narrowly says to doctors, if you want to call them doctors, don't give this therapy. We find it's dangerous and ineffective. Licensing agencies do this all the time, in the law, we're familiar in the malpractice area with the standard of care, where if a physician harms you and goes outside the standard of care, he can be sued. Indeed, the majority opinion says malpractice is good enough to solve this problem if the therapy is dangerous. But that's nonsense, because what comfort would it be to parents whose kid commits suicide that they get a big malpractice judgment later, So that's what I would say, is that it's not an attack on speech. You can still advocate all you want for conversion therapy, but you just can't give it as a... Well, one way to look at it is that you can't charge the insurance company for it anymore. I mean, that's the only thing that the law really accomplishes. You can still give the therapy, you just can't call it a approved medical therapy.
Thank you. Apparently in 2011, the Florida legislature passed a law prohibiting doctors from asking their patients if there was a gun in the home.
I was a lawyer on that case. Carry on.
And so that case made it to the 11th Circuit.
I was there.
And the 11th Circuit said that law was unconstitutional.
Correct.
You agree that with that outcome, that the Florida legislature passed an unconstitutional law?
So, and as someone who was in the Solicitor General's office defending that law, including at the 11th Circuit en banc, the component of the law that was struck down was where the doctor was able to, simply ask about gun ownership, right? And so how, to any patient, how attenuated that was, and because the Second Amendment right, another constitutional right, was baked into that, and really there was no nexus between the practice of medicine and what the state was trying to tell doctors what they can or can't do. And so, yet again, as a matter of First Amendment, the 11th Circuit said you can't tell doctors they can't ask about gun ownership. You can tell doctors they can't harass patients, right? But we already have laws against harassment. We already have laws against medical malpractice, coercion, fraud. And so when there's laws already on the book that regulate conduct, usually the legislature or the state needs to show that there has been a problem and they've had to use those laws, or the conduct's actually happening before they can come in and regulate speech. So without, throwing my prior client under the bus, I think the outcome there is consistent with the outcome here.
Yeah, I don't see anything wrong with that. I mean, and I see nothing wrong with a doctor voluntarily asking a patient, do you have any guns in the house? I wish the doctor of that jackass in Louisiana had asked that question yesterday before those 8 children were killed. Second Amendment martyrs, I guess we'll call them.
All right, any other questions from anybody? All right, well, thanks again to our 2 debaters. Pam? We got a question?
Actually had one question.
Okay.
So you mentioned that gender-affirming care can be banned even with this new ruling because it is an actual action. They're going in and providing medication and things like that. My question is, would that also allow for states to say that a 16-year-old is not allowed to get a nose job, because that would also fall under the idea of gender-affirming care? And how would that different? My question, I guess, would be more, where does the line get drawn as to what is regulated on children's health care?
Well, there's no constitutional right to plastic surgery. So actually, yes, the state can have regulations on, certainly, especially in the realm of minors, on procedures like that if they wanted to. That's, yes, without getting more complicated about the background of Scrimeti, yes, the state has authority to regulate and limit procedures and conduct done on minors. Florida's law that was similar to the one upheld in Scrimeti was also upheld as to transgender medicine. But I think you could certainly make the case for elective, regrettable surgery on minors, for whatever reason, being restricted.
All right, Pam, you had a question? Right up here.
What was the question again?
Could they restrict nose
daydreaming it.
jobs?
Huh?
Could they restrict nose jobs or just random surgeries for minors?
Oh, yeah. Well, I'm all for it. Successful nose jobs. No, but there was another point to the question. What was the question? Oh, yeah. I think you said that it's okay to ban gender-affirming treatment. From the Scrimeti case.
Would that mean that
Yeah.
it's also okay to also ban things like nose jobs?
Oh, I see. Well, if you buy Scrimeti, I guess it would extend to that. But I don't buy Scrimeti. There's a lot of cases I don't agree with. What I find ironic and kind of sad is that the child's court said that the real tip-off that this is viewpoint discrimination is that the Colorado law tips its hat to gender-affirming care while at the same time getting rid of conversion therapy. While the court says Tennessee is correct, it's fine to ban gender-affirming care. I'm getting confused here, but my point in all this is that there is no, you can't control doctors or have a standard of care without taking a viewpoint. So the distinction that the majority makes between viewpoint discrimination and content and speech is speech and all that is, it doesn't really work for the child's case. Because of course the banning of conversion therapy was a viewpoint move by the Colorado legislature. But they did not attack conversion therapy because it conflicted with the state's viewpoint on homosexuality as a good thing. It attacked conversion therapy as ineffective and harmful, regardless of anyone's view of homosexuality. And I would point out that it is the absence of data to support a regulation or a law that tips you off to the possibility that that law is the result of viewpoint discrimination. And I'm thinking that the court's decision in Scrimeti may indeed have been an example of that kind of viewpoint discrimination.
All right, and before Professor Harle tells us about the First Amendment Clinic and the great work she's doing there, let's give both debaters a rousing round of applause for an excellent discussion.
I can't believe it's over. We just started.
We got some people that have to go back to work. I know Alvin doesn't have to go, but Jay probably has to go. So.
Well, I'll be brief. Thank
Go
you for the chance to do this. As I was mentioning with some of the folks that were in our lunch beforehand, most law schools have something that's called legal clinics. They'll cover different areas of law, elder law, business law, immigration law, so many different opportunities you can have, wrongful convictions. And so FSU does have a few, but I sort of got this vision about a year and a half ago that I wanted to create a First Amendment clinic at FSU. There wasn't one in the nation that actually defends all 5 freedoms of religion, speech, press, assembly, and petition. And there are only a handful at all that dabble in religious liberty and speech, or speech, really. And so I'm very thankful to say that I was able to find the funding, get approved to be faculty, and the Institute for Governance and Civics at FSU, if you've heard about that, it's a new civics education institute, public policy institute that the legislature has written into statute, has helped me launch this clinic. And I have students enrolled. They get about half of their course credits for the law school by working on real cases for real clients. It's all pro bono. And it's been tremendous. The students start with a blank Word document and then end up filing a brief that they have written under close supervision from supervising staff attorney and me. We have defended student speech. We've fought against compelled speech. We've fought against speech bans. We've fought against religious discrimination in the workplace. We fought for freedom of the press. And already in just 4 months have, I think, filed now 4 appellate amicus briefs and issued 3 demand letters and done another comprehensive legal memo. So if you are thinking of going to law school, definitely think about the opportunity to get real world experience, practically doing litigation or transactional work if that's what you're interested in when you're in law school. And if you are a supporter of the First Amendment, and that's why you're here, I would love to talk with you. The university and the law school don't fund the clinic at all, and so forever I'm going to have to raise money for this. So I would love to talk to you about a sponsorship for an event, or if you're a lawyer and you'd like to co-counsel with us, we would love to get the students to work alongside other attorneys and grow that way. You can also subscribe to our Substack newsletter so you can see what we're doing, and you'd be welcome to come to any of our events, which are also lively and engaging like this one, and always free.
We got time for a couple questions about the First Amendment Clinic.
He wants to debate about my clinic, I think.
No, I just wanted to say or ask, the state of Florida is not very friendly to, or hasn't been, to First Amendment rights, is it? I mean, you must have a lot of Florida cases to deal with.
We prioritize Floridian clients, but we have really cases all over. I mean, the First Amendment is a problem from all directions.
Sure.
Lots of state and federal cases. Because I'm at Florida State University, which you probably know is an arm of the state, I can't sue myself. So that limits some of our cases.
All right, we have any questions about the clinic itself? Anybody?
First in Florida. Thank you for asking. First in Florida.
All right, anybody?
You might be photographed on there tomorrow. Maybe have a group shot of this. Subscribe now.
All right, I don't see any more questions. Let me just leave you with this from Justice Gorsuch's majority opinion in Childs. He said, the First Amendment envisions the United States as a rich and complex place where all enjoy the freedom to think as you will and to speak as you think. Often, speech may prove illuminating and inspiring. Sometimes it can be misguided, offensive, or cause incalculable grief. But either way, the First Amendment protects the inalienable right of every individual to decide for himself how best to speak. In this nation, no official, high or petty, may command our tongues or silence our voices. Thank you for coming. Let's give our debaters another round of applause for that excellent job. Thank you all.